Welcome, and thank you for attending our quarterly docket today. This is a quarterly review of all things compliance as they relate to absence and disability. A couple of things before we get started. We are recording today's session, and all registrants will receive a copy of that recording as well as a copy of the presentation slide deck. If you have any questions, please use the question features at the bottom of the screen, and we'll answer as many of those questions as possible towards the end of the presentation. All of our presenters today are from our Reliance Matrix compliance team. That would be Lana Ruprecht, Shelby Felton, Eric Broutman, and Nell Walker. As an additional side note, we will also all be attending the DMEC conference in Nashville on August 5th through August 8th. And during that conference, we will be presenting on 4 different topics. So if you plan to attend that conference, and we hope that you do, please be sure to attend these sessions and stop by our booth to say hello. Now I'll turn it over to Nell to get us kicked off and to go through the agenda.
Thanks so much, Monty, and good day, everyone. To echo Monty, and on behalf of the Reliance Product and Compliance team, I'd like to welcome you to today's docket, Reliance Matrix's quarterly series highlighting key developments in the absence space. I'm Nell Walker, Reliance Matrix's Vice President of Product Compliance, and I'm pleased that you can join us for today's presentation. We've got a great agenda and panel for you today. First up will be Lana Ruprecht, our Senior Product Compliance Counsel, with an overview of the Pregnant Workers Fairness Act, both requirements under the PWFA and some recent challenges to its application. Following Lana, Becca Ford, head of our PFML products team, will walk us through important reminders and updates in state paid family and medical leave. Becca will be followed by Shelby Felton, her PFML product compliance partner in crime, who will give us an update on legislative developments you should be aware of. Eric Broutman, our litigation expert, will then share some recent regulatory and litigation developments and actions of note. Lana will then wrap up our presentation at the end of the session with this quarter's compliance lesson, answering the perennial question, can you choose whether to use FMLA time? Finally, time permitting, we'll take some Q&A. And with that, let's move into our program. Lana, take it away.
Thank you, Nell. So we are starting with the PWFA today. As you may have heard, the final regulations interpreting the Pregnant Workers Fairness Act went into effect on June 18th, 2024. As a result, we've been very busy. We have several resources out there for you that specifically focus on the PWFA. We have a pre-recorded webinar. We have 10 podcasts where we dive into specific PWFA topics. We also have a white paper coming out that covers not only the PWFA, but all laws that offer some type of pregnancy-related protections. We also just recorded another webinar on the PWFA where we address some of the many questions we have been receiving relating to the interpretation under the new regulations. This slide links to some of these resources, and make sure you are subscribed to our blog as you will receive the most recent updates on the PWFA and the resources that we're publishing. So today, the next slide discusses the agenda for the PWFA. I'm just going to touch on some key highlights. I could speak for 2 hours about the PWFA, but we're going to go through some quick highlights, which include first, the concept of predictable assessments. Next, we'll discuss how the PWFA has 2 definitions of qualified employees. Next, the documentation requirements under the PWFA, they're different from the ADA. We will go over what is not covered under the PWFA. And finally, we want to give you an update on some litigation associated with the Pregnant Workers Fairness Act. So let's start with predictable assessments. What are predictable assessments? Well, they are modifications that a pregnant employee may request as an accommodation. They are identified in the final regulations. They include carrying water and drinking water as needed in the work area, requesting additional restroom breaks, requesting to sit if your job requires you to stand or the opposite, additional breaks beyond what is already permitted to eat and drink. The EEOC has stated that these modifications, if they are requested by a pregnant employee, are almost always reasonable and will rarely cause undue hardship. Also, if an employee asks for one of these modifications, the employer should provide them quickly and generally may not request medical documentation to support these type of requests. That means if you are thinking as an employer of denying a request that falls into these categories on the basis of undue hardship, or under the circumstances you feel like you need to ask for documentation to support one of these types of requests, be very careful as to how to proceed and consult with your attorney. Next, let's discuss qualified employees. While only qualified employees are eligible for PWFA protections, the Pregnant Workers Fairness Act has two different definitions of qualified employees. The first one is familiar to most employers. It requires that employees be able to perform the essential functions of their job with or without accommodation. But the PWFA has a second definition. An employee is considered qualified even if they are unable to perform an essential job function. But the following three elements need to be met. One, the inability to perform the essential job function is temporary. Next, the job function can be performed by the employee in the near future. And finally, the inability to perform the essential job function can be reasonably accommodated. As you know, this is a significant departure from the ADA. Next, there's the in the near future definition. Under the Pregnant Workers Fairness Act and their final regulations, they define in the near future as meaning that if the employee is pregnant, it's presumed that the employee will be able to perform the essential functions of their job within 40 weeks from the job function being suspended. But if the employee is not pregnant and is still covered by the Pregnant Workers Fairness Act, the term in the near future is more of a fact-specific determination. There's no 40-week presumption. Note that is different than what the proposed rules stated. The final rules limit the 40-week suspension to pregnant employees only. Next, let's cover documentation requests under the PWFA. They are also treated differently than the ADA and what a lot of employers may be used to. An employer's ability to obtain supporting documentation is more limited under the PWFA. The PWFA regulations say that both the request itself and the type of documentation requested must be reasonable. According to the regulations, a documentation request is reasonable if it's limited to confirmation of the physical or mental condition and the adjustment or change needed because of the limitation. Requests for supporting documentation are not reasonable under the PWFA if the limitation and need for accommodation are obvious and the employee provides what's called self-confirmation. Next, the employee already has sufficient information or documentation. Another time it will not be reasonable to request documentation is if the accommodation involves lactation or pumping at work and the employee provides self-confirmation. Next, if the pregnant employee requests one of the predictable assessments we talked about and provides self-confirmation, an employer can, generally, it's not reasonable to ask for documentation. And then finally, if the employer's policy doesn't require supporting documentation for other accommodations asked by employees who aren't covered by the PWFA, then an employer cannot ask for an employee to provide documentation under the PWFA. So I mentioned self-confirmation. Quickly, I just want to let you know what that is and how it's defined. Under the regs, that's a statement by an employee just confirming they have a limitation that's covered by the Pregnant Workers Fairness Act, such as they are pregnant, they're trying to get pregnant, recovering from pregnancy, etc., and that they just need an adjustment or change at work. It's a quite simple statement. It can be made part of the request for accommodation, and the employer can't require any specific type of form or format to obtain any kind of self-confirmation. Now, what's not covered by the PWFA, because it's quite broad? Well, it does not apply to bonding claims. That's really clear from the regulations. Also, there's no requirement to accommodate an associational claim. So the regulations have the example if a spouse or partner wants to take time off because of anxiety they are experiencing due to their partner's pregnancy, that is not covered. They are not covered by the PWFA in that instance. And there's no requirement under the PWFA to pay for abortions or transportation related travel costs. And finally, I want to touch on some lawsuits that we've come across related to the PWFA very recently. One lawsuit involves 17 states that were challenging the final rule that went into effect on June 18th, saying just with respect to how the rules discuss accommodations for elective abortions. In that one lawsuit, it was dismissed because the court determined the states did not have standing to challenge. But there's another lawsuit brought in federal court in Louisiana. And as of June 17th, employers in Louisiana and Mississippi are enjoined from accommodating elective abortions under the PWFA. In that case, the court held that the EEOC had exceeded its statutory authority to interpret the PWFA. So we are following this and tracking these cases and any additional cases that may come up. Check out our blog for more updates. And of course, at our next quarterly compliance update, we will address anything else that arises as well in this area. So with that, that's a quick summary of the PWFA. Like I said, I could talk a lot more, but we check out our resources for more information on that. And now I will turn this over for our PFML update to Becca Ford.
Thank you, Len. I appreciate that. It certainly is a lot to think about right now with PFML. Want to start out actually with a few reminders. Shelby Felton presented on this topic in our April docket series. Big reminder here is that Oregon's had a lot going on. I'm sure you recall the multiple slides for Oregon last time around. The big takeaway I want you to understand for these reminders is that there's now a carve out between OFLA and Oregon PFML. We think of it as an alignment, and it's not to say that they're both the same. It's to say that now they cover different topics. So where there was an overlap, there no longer is an overlap. And that became effective just this month, the first of this month. The big takeaway here is that OFLA, and just like I had mentioned, OFLA and Oregon PFML will be covering different topics. So PFML is available still for bonding, leave for a serious health condition for yourself or your family member, and safe leave, whereas OFLA now is available just for bereavement, childcare leave, and pregnancy disability. So really important to highlight that. I know there's been a lot of changes in Oregon. Also want to call out that, because they're different leave reasons, you're not going to see them run concurrently, but FMLA would run concurrently with OFLA and can run concurrently with Oregon PFML. Reporting has also expanded, and I say that in the sense that we were very used to Massachusetts not having reporting. I think we were spoiled for a while with that. And then Connecticut PFML being our reporting requirement that we got used to. Now at the passage of Colorado and Oregon, and Massachusetts just not wanting to, they don't want to feel left out. So they're offering requiring reporting right now, as well. Colorado is going to be quarterly. So it ends up being a cumulative report. And what I mean by that is for Q1 through Q2, you're not building, or you're not looking individually at each quarter. You'll be building on the quarter. The good thing is if you're fully insured, that's an aggregate reporting. And what that means is that the carrier is going to be reporting the block of their data for fully insured products. So it won't be an employer requirement. For self-funded, they are requiring reporting by FEIN. So if you recall, most states offer through their private plan application process, you're reporting each one of your affiliates or each one of your FEINs that's impacted by the state law. So there will have to be a report that would coincide with that FEIN that has the private plan exemption within these states or equivalent plan for Oregon. Those will, at least at Reliance Matrix, we're providing those reports for our groups. So be on lookout for that if you are one of our clients. For Massachusetts and Oregon, they're following the same setup. Fully insured would be aggregate reporting. Self-funded would be per FEIN. Want to make a few call outs here though. So we see these different timing requirements. Colorado, as I had mentioned, has this quarterly model, whereas Massachusetts is running an annual update, but it's on the fiscal year. So August 31st will be the first reporting period for this year. And then Oregon, it will be due annually beginning January 1. And that first report will be data from 2023. If you remember, the program began September 3rd, 2023. So more information on Oregon. They just can't stay out of the news for PFML. They like to be in the limelight. The Paid Leave Oregon division will be actually reaching out individually for renewals. And what that means is the state is going to issue a letter to anyone that has an equivalent private plan, and they will have to file their issued contract or their plan template with the state, showing that they have coverage for the year from 2024 to 2025 through their portal. And that process is going to be detailed on the Paid Leave Oregon site. It's going to look a lot similar to what happened when you first applied for the equivalent plan process, but the fees will be different. As long as there's no amendments, the fee is going to be $150. So a little bit of a savings there. Any amendments would mean that the fee would be the same from your original application period. I also want to call out what Oregon's done. If you recall, Oregon has a September 3rd start date, which was quite honestly, I think, very challenging for payroll, for contract issuance, and even just remembering when the program began. So they're realigning those contracts now to an October 1st. And Oregon is a first of the quarter effective date. So now all September 3rd contracts will realign with a 10/1 date. This is really just for ease of administration going forward, having this first of the month renewal. And we'll see that then going forward. So continuing forward, anyone that was 9/3 will be a 10/1 as long as you have an equivalent private plan approval. Mid-year updates. We have mid-year updates for Colorado, Oregon, and Rhode Island. Important call out here. So what I mean by mid-year updates is that these states issue new state average weekly wages as of July 1st. Now, that's not just specific to the paid family and medical leave program. The state average weekly wage also impacts unemployment. So this is more of a Department of Labor issuance. You can see here that there's been an increase in both SAWs, as we call them, for both Colorado and Oregon. But what I really want to call out here is if you look at Colorado, we're very used in the industry to having impact to new claims from a date going forward. But Colorado is impacting our in-flight claims as well. So if you have an employee that's out on leave, they're actually going to get a bump in their claim payment due to the realignment with the new state average weekly wage. Since that increased, that's what impacts the benefit payments and the benefit calculation. So with the new SAW being the number that you said there, the 1,471, that's going to impact what the calculation is for that benefit amount. They're the only state that has an alteration in flight, but just something to be aware of and to make note of. The other thing that I want to make note of for Colorado is that their state average weekly wage, which would usually impact the maximum benefit, as I had just discussed, that it impacts the benefit payment. That calculation is actually going to be frozen until next year. So the program began with a maximum benefit of $1,100 a week, and that will remain that way until January 1st. Thereafter, it will update, and then it'll update again July 1st, 2025. So something to just be aware of. You're going to see some changes in Colorado early part of 2025. For Oregon, more something that we're similar to is that this impact that would just be for new claims on or after the date. Now, Oregon not wanting to not shine. They are effective July 7th is their state average weekly wage update. Some carriers may have aligned with the July 1st date. I know Reliance Matrix, we have done that just for ease of administration. So if you're a Reliance Matrix client, that is effective for our clients as of July 1st and will impact new claims on or after July 1st, the state being July 7th. And Rhode Island, they also had a mid-year update effective 7/1. They had a change to their minimum and maximum benefit and also the dependent allowance. Really, we like to call this out, Rhode Island is a state-only program. There are no private plan options, but really like to call this out because this can impact offsets for your disability products. So something to be aware of for clients within Rhode Island. And I also want to call out here that they've made an expansion, quite a large expansion actually. Their temporary caregiver duration, which is most similar to PFL, if you can think about it that way, has increased to 12 weeks. So a big expansion for their program. So the next couple slides here, I called on the horizon. These are our states coming forward for implementation in 2026. And it's the first time that we've had 4 states. So last time, the implementation period for Oregon and Colorado, you had 2 states at once to think about. Now you have 4. And most are, on the East Coast, which makes it even more challenging for employers in that segment. Delaware, Maine, Maryland, and Minnesota are the states coming live. And just kind of want to go through and give you an update on what's happening. Each state's doing something a little bit different. So in Delaware, we've gone through a period of regulations, which we had and were reviewing along with the statute and creation of products. Now we have new draft regulations that have been released. There's been a lot of back and forth in Delaware about the regulations, about the changes that are being made. So still a work in progress. Reliance Matrix is one of the stakeholders that is working very closely with the state and other stakeholders in the development of draft regulations and the development of private plan options. And just to kind of run through that with you quickly so you understand what the impact is right now. Employers currently have an option to opt out. So that's what you most similar to the exemption process that you've seen in other states. So, thinking back to Mass and Connecticut and Oregon and Colorado, they all had some format for private employers to say, I really want to have a plan through a private carrier or a self-funded program through an administrator. How can I get out of the state program but still offer this mandatory requirement? So that's that opt-out. Delaware still hasn't drafted what that looks like. The main component that you need to be aware of, when I say what it looks like, they don't have the process in place yet. But employers can expect that they would have to provide an issued contract, which is the first time that we're seeing this in a PFML state. Typically, contracts aren't issued prior to coverage beginning. So this is a little bit new for everyone. And with the new regulations, there's just a little bit of back and forth still through this process. But the opt-out has 2 periods. It's September 1st to December 1st of 2024. And that would opt employers out of paying contributions to the state for that first cycle of contributions. The second cycle would be for 10/1/25 to 12/1/25. And that would mean that employers would be paying the first pre-fund into the program, but then would be exempt beyond when the program begins in 2026 from paying contributions. So again, something that's still being ironed out. You can expect to see more information as we receive it from on Absence Mentor. Make sure you follow the blog. There'll be more information on it, but just something to be aware of. Maine, we currently have no opt-out provision. So at this point in time, again, Reliance Matrix is working with the state and other stakeholders to develop this process and encourage the state to adopt a process. But at this point in time, employers would be expected to pay into the state program and premiums or fees to a carrier or administrator for their private program. A lot of times when new states come online and begin their implementation process and developing regulations, it's new for them. It's not new for other stakeholders like Reliance Matrix and other carrier organizations. So it takes some time for states to understand what the necessary formula is to get it right. In this case, I'm not quite sure, to be honest, what is going to transpire in Maine, but we are continuing to follow it closely and work with the state, as I had mentioned. Their draft regulations are currently in process, and that is something that Reliance Matrix has been a part of as well. And the one exciting piece I can tell you is that they do have their rate announced. This rate will actually run until 2027, so we won't see a new rate assigned until 2028. And at this time, employers with less than 15 employees would have a contribution of 0.5% of their wages. So that can mean that the employees would be paying up to the 100% of that. Employers always have the option to share that amount, but the requirement would be at the state level that the employees would be paying that 100%. Employers with 15 or more employees, their contribution is 1%, and it would be shared amongst employers and employees equally. Again, the employers always have the option to pay that full vote, but that is the state requirement. Maryland has been very organized in their process for drafting regulations. They're looking to finalize to the end of 2024. I also feel like they've been really receptive in taking carrier feedback. Reliance Matrix, again, is a stakeholder in the development of those regulations as well, and has been very active in that process. The one thing I really want to point out is that this program's been pushed back 6 months. So early on, this is several months ago, there had been legislation discussing that there would be potentially a 6-month delay. We were waiting for that signature from the governor for a while. That did pass. So now instead of 1/1/25 and 1/1/26, we're looking at contributions beginning July 1st, 25, with benefits beginning July 1st, 2026. It's a lot to remember with the different dates falling off of cycle, but we'll help keep it all straight for you. There will be a bulletin that will be released in April of 2025, and that will include filing instructions and a policy template. So you can expect a private plan process from Maryland. Finally, Minnesota. Reliance Matrix is working to develop regulations with other stakeholders in Minnesota as well. We don't have any draft regulations yet, but that has been a work in progress. They're very active in working through drafting regulations and making changes. There were just a bunch of amendments made to their statute through a fix bill. The important thing that I really want to call out here in Minnesota that's really unusual from what we're used to in other PFML states is that there's no pre-fund period. So when the bill passed, it actually had funding tied to the bill to pre-fund the program. So that means that there's no contribution timeline. The benefits will just begin January 1 of 2026. So through that regulation process, we'll have a better understanding of how employers will be able to file for an exemption from the state program, but there's no pre-fund period that employers will have to try to get out of if they want to have a private plan. Now, I had mentioned that Minnesota just made a bunch of amendments through a fix bill. I won't run through all of them right now, but Shelby Felton did a great article on the Absence Mentor blog about all of the changes and the whirlwind that's happening in Minnesota, because they're really active in making changes to the program. You can see some of the call outs here for the amendments. They're on big topics: adding employer reimbursement, changing the coverage for former employees. These are all really big topics and provisions that shape the policy themselves and what the program will look like. So I encourage you to take a look at this blog article. I know there's been so much going on. So is that it? Is that it for this year? That's it for this year. We don't have anything else coming forward as of right now. That doesn't mean that there won't be more PFML states coming forward next year. You can fully expect that there will be other states that will pass PFML. This year, we've seen a huge influx. Almost every state has had some form of legislation put forward. Most have failed, other than the ones that you've seen me mention. But please stay tuned, because you can expect that whether it's mandatory paid leave or PFL as a form of insurance, you're going to see more legislation passed in that arena. So what's the latest? What's new? So we talked about all these new states that are implementing, but what's going on with the states that have already implemented? New Jersey, actually, for a while, we haven't seen a contribution rate for that state, and it's been kind of an interesting development. But reports have been circulating that there will be a contribution for 2025. So this is something that we'll find out in Q3, Q4 of this year. But that would be a big change to employees who haven't had this amount come out of their paycheck in the past 2 years. But the state really looks like they're going through a shortfall and a deficit when it comes to these programs. So they're going to have to start levying that tax again. We don't know how much it'll be. That would be through that annual update process, which we do communicate about. So another topic to look at Absence Mentor for. Washington, the same thing. The program has just grown substantially. A lot of it was initially thought to be a boom through COVID. There was so many claims being filed at that time. And if you remember, Washington was an early adopter to the paid family and medical leave program. So there was concerns over time through as COVID was kind of having this boom of claims, that then it would quiet down eventually, which it hasn't. So there's the big concern right now is that there would be a deficit as early as October. So you can expect that there would be a rate increase again for Washington in 2025. And we'll keep you posted about that. Again, another topic that would be on Absence Mentor. And finally, I had mentioned NCOIL and the paid family as a form of insurance. So what is NCOIL? This term's been tossed around a lot in the legislative landscape discussions. It's really just a body, it's kind of like a think tank, National Council of Insurance Legislators. They draft model rules and regulations, not just for paid family products, but they also draft for disability products or life products, dental products. So it's very expansive. I like to think of it more as this model rule is for changing the insurance code to include now paid family leave. So essentially what happened is that these group of legislators created this model rule for states to adopt through their insurance code as an employer-sponsored benefit. So just like DI product or a life product. Now, in these states listed here in this chart, you can actually carriers can file a paid family leave product that could coincide with STD or just stand by itself. And it would be up to the employer as to whether they would want to provide this option. So, just another bucket to be aware of in the landscape. It really just creates more of a free market for these types of products rather than the mandatory requirement that you're seeing in the other states that we had just discussed. And now I'm going to turn it over to Shelby Felton.
Thanks, Becca. I'm going to give everyone a quick legislative update. First, we had some changes this session in the Minnesota Pregnancy Accommodations and Parental Leave Law. Basically, employers must now continue health insurance coverage while someone is on leave, and prenatal care appointments will not count against the 12-week leave entitlement. These two changes are effective on August 1st. We also had a change to Minnesota's Human Rights Act. That act prohibits discrimination based on a number of protected classes, including familial status and disability. These changes are also going to become effective on August 1st. The changes extend the definition of familial status to include those who reside with and care for adults with disabilities who need assistance or care from another person. These changes also expand the definition of disability so that it is consistent with the ADA. Connecticut's SB 222 added sexual assault in addition to family violence as leave reasons under their family violence statute. What didn't change with this is that it's still limited to only 12 days. New York this session became the first state, and the governor touted it, to pass a standalone law specifically requiring that employers provide employees with paid prenatal leave. Starting on January 1st of 2025, all employers must provide 20 hours of paid leave for prenatal care during any 52-week calendar period. This new prenatal leave is a self-contained bank of leave. It's not part of New York DBL. And while it is an amendment to New York's paid sick leave statute, it's separate and apart from that paid sick leave. It also doesn't appear to accrue like paid sick leave, but I'll tell you, we're still waiting for regulations to clarify exactly what's going to happen with this prenatal leave. Lots of changes in Illinois this session. In the state, it's Paid Leave for All Workers Act. We got some final regulations. So this is the act that allows employees to accrue 1 hour of paid leave for every 40 hours worked, up to a minimum of 40 hours of leave in a 12-month period. In Cook County, we got final regulations on paid leave, including much needed clarification on whether the law overlaps with the state, back up to that Paid Leave for All Workers Act, whether it overlaps with the state law or, as we're going to talk about in a minute, local leave laws like in Chicago. The new rules have a ton of requirements, and so we're really encouraging employers to engage with their employment counsel for assistance on this one. Effective July 1st of 2024, so just 11 days ago, 10 days ago, the Chicago Paid Leave and Paid Sick and Safe Leave Ordinance now allows eligible employees to accrue up to 40 hours of paid leave and 40 hours of paid sick leave in a 12-month period. So eligible employees will accrue 1 hour of paid leave and 1 hour of paid sick leave for every 35 hours worked. Now, while Reliance Matrix doesn't administer any of these programs in Illinois because they are accrued leave programs, it is important that employers with employees in Illinois are aware of all the changes that happened this year. And that is our very brief legislative update, and I will pass it on to Eric for our regulatory guidance.
Thanks, Shelby. Appreciate that. That's great information. So hi, everybody. I'm going to be taking us through our regulatory and litigation updates this quarter. And starting first with our regulatory updates, the EEOC has issued new workplace guidance on harassment, which covers protected employees from harassment based upon their protected characteristics. And most importantly, they've updated this guidance to include unlawful harassment regarding telework, digital technology, and social media. So it's important to take a look at that because harassment can take place even if it's not actually in the workplace, but if employees are harassing other employees through these technological means. We also have new field assistance bulletin from the Department of Labor, and this specifically addresses the use of artificial intelligence in leave and break requirements. In specific, they cover processing leave requests, FMLA certifications, and FMLA interference and retaliation. And the Department of Labor really emphasizes that there's some sort of human oversight with these AI programs, that we just don't let the programs make determinations because there can be particularly idiosyncratic situations where humans need to make individual determinations. They also point out scheduling of breaks for the Pump Act when individuals need lactation periods to express breast milk, that needs to be overseen by a human eye as well. Now moving on to our enforcement and litigation updates, the fun stuff. So starting first with our EEOC settlements, and we have a rather large one right up front for just over $1 million with a 5-year dissent decree. Here, an employer failed to provide communications accommodations, including sign language accommodations for deaf and hard of hearing employees. And they had a policy of terminating employees who requested medical leave but did not qualify under the FMLA because of tenure reasons or hours worked reasons. So the lesson there clearly is, if regardless of the reason, if individuals are disabled, it's important to consider those accommodations. Next, we have somewhat odd case where this was a pharmaceutical company that was specifically requesting information about whether or not their potential employees had hemophilia or their children had hemophilia, and the medications that their children took for this hemophilia, and they pressured those employees to use their pharmacy services for these medications. Essentially, they were looking to hire customers so that they could make them buy their products and earn money off of their own employees. But this stands for the point that you're not allowed to ask employees about their medical conditions, right? That I think seems pretty clear, regardless of the reason why. These are not questions that we can ask people. Moving on, we have a $75,000 settlement with a consent decree as well, where a female employee was required to participate in the employer's employment assistance program. And what's somewhat important here is the female employee here had complained of sexual harassment regarding a male employee. Not only did the employer do nothing about those complaints and the sexual harassment, they forced this employee to undergo the employment assistance program, where there would be mental health counseling. So almost blaming her, saying that there's something wrong with her for complaining about sexual harassment. They seemed very lucky to me to get off with only paying $75,000. And finally, on this slide, we have a case where an employer had to pay $125,000 after they knew about an employee's high-risk pregnancy and associated disabilities and failed to provide those accommodations and then fired the employee. So the simple premise, don't fire pregnant employees simply for being pregnant. Moving on now to our next slide, we have a settlement for $57,000, just over 57, in a consent decree where a former employee claimed that they were terminated 5 days after discussing their disability and discussing the potential need for a related accommodation. Clearly, it seems as though that termination was the result of them asking for an accommodation. If you're going to terminate employees near or at the time that they're requesting some form of an accommodation, make sure that there is a clearly defined business reason for that adverse employment action. Next, we have a $75,000 settlement with a 2-year consent decree where the employer violated the law when they disclosed the fact that an employee had HIV, and then that disclosure to other employees led the other employees to then harass this individual because of their HIV status. So it's important to keep information that we get from employees when they're asking for accommodations, when they're asking for any form of leave. We keep that as private as possible, only disclose it to those that necessarily need that information. Next, we have a $720,000 settlement where an employer was accused of numerous instances of failing to accommodate and then firing an employee with colon cancer who also had an ostomy bag. Not much to say there. And then finally here we have a case for the settlement of $325,000 in a consent decree where the employer fired an employee and said that their health benefits would end after the individual received a large bill for a surgery. Essentially, they were worried about future large insurance bills, and therefore they terminated this employee. Clearly, that is not permissible. If an individual needs treatment and qualifies, that has to be provided regardless of the cost. One more thing I wanted to say before moving on to the lawsuits is with the settlements, a lot of the times you see these consent decrees, and I know I mention this every time, but I think it's important. Those consent decrees matter. Even if the amount of money you're not paying isn't particularly huge, the consent decrees that the EEOC requires often take a lot of time to report back to the EEOC to ensure that you are complying with the laws, and they can be almost as costly sometimes as the monetary settlement. So be mindful of that. Now on to these EEOC lawsuits. Here the EEOC initiated a suit where an employee was fired after requesting a reasonable accommodation for visual impairment that would allow him to access information to perform his job. Visual impairments, hearing impairments, these are some of the most common things that accommodations are clearly required for. So that's important to know. Moving on next, we have a scheduling assistant who informed their employer about, again, a visual impairment and the need for an accommodation, and the employer questioned why she didn't raise the issue in her interview and immediately terminated her. I see things like this fairly often where employers somewhat get mad at employees for not mentioning the fact that they could not do certain things or they needed an accommodation while they were during the interview process before they were hired. And they'll say, well, this person never told us about that. They're not required to at that point in time, right? They're required to inform you of their disabilities when they're asking for an accommodation. And even though they may have agreed to a particular schedule at the beginning, if an accommodation is needed and a disability arises, those can change. Moving on now, we have our FMLA cases. Mary McBeath versus the City of Indianapolis out of the Southern District of Indianapolis. Here, an employee was fired 2 weeks after their FMLA leave started, but there was no violation because the employee's reasons for termination was theft. So it was completely unrelated to the leave. It was for a valid business reason. So it's really important to document that, to make sure that there are distinguishable reasons if you're going to take an adverse employment action against someone who is about to start or who is in the midst of a leave. Moving on, we have Chris Bell versus FCA US out of the Sixth Circuit. Here, an employee with anxiety and depression was unable to comply with the company's internal policy of providing a call to let you know that you're not going to be coming into work within 30 minutes after you're supposed to be scheduled. And the court allowed this case to go to a jury. They denied summary judgment because they said this could be one of those unusual circumstances that the FMLA contemplates, where an employee has an unscheduled leave, an unforeseen leave, and is unable to inform their employer immediately, and they may need to be given some grace outside of the policy that's in place so that they can inform their employer as soon as practical. Next, for our disability accommodation case, we have Anik versus the Kroger Company of Michigan out of the Sixth Circuit. Here, the employee returned from breast cancer surgery, complaining that her job was hard for her physically and she was struggling and needed some time to get back to normal. The court held that was a request for a reduced or modified work schedule. So the important lesson here is that when employees are asking for accommodations, they don't need to use any sort of magic words. They don't need to say the word accommodation. They don't need to mention the ADA or a disability. They really just need to say, I'm struggling with something because of a medical reason and I need some help. And then the ball is in the employer's court, where they need to then initiate that interactive process. They need to put the ball back in the employee's court, let them know how they can request the accommodation, that these things are available to them so that you've done your job as an employer. Moving next to Donna Jones versus Fairfax County School Board out of the Eastern District of Virginia. Here, I find this case really interesting because a teacher was suffering from a respiratory disease and they couldn't be around mold or dust, and they requested remote work. But the employer stated that being present at the job is an essential job function, that this person was a teacher. The court here agreed, and they said that the request was not reasonable. Now, I know since COVID, a lot of people are working remotely. A lot of people did work remotely, including school teachers were teaching remotely. But it's good to see that courts really are taking into account that even though something was done previously by remote means, that teaching especially is something that is an essential job function, is being present. There are other jobs like that as well. So it's important to make sure you have really robust and up-to-date job descriptions, so that if you are faced with this challenge, you can put your best foot forward to show what are and are not essential job functions. So more disability accommodation cases. We have Najee Long versus Kelton BW Inc., where again, we had someone who was a teacher in a daycare. This was out of the 8th Circuit, took time off for surgery. And then when they came back, the employer assigned them to a preschool room to accommodate their post-surgery lifting restrictions. The teacher was then fired for poor attendance because she couldn't appear. So the court held here two things. One, appearance at work is an essential function of the job, and missing this amount of time, particularly when we're talking about daycare and infants, even though it wasn't a very long period of time the person was out, that need not be accommodated because being present was essential. And secondly, this individual did not meet the definition of a disability because their difficulty was the result of a surgery. It wasn't any sort of underlying medical impairment. It was temporary, and therefore the definition of disability didn't apply. Next, we have Samantha Howard versus the City of Sedalia, also out of the 8th Circuit. Here we have a pharmacist who requested a service dog for diabetic reasons, and the employer denied the accommodation for hygiene reasons. What's important here, and I've seen a couple of these cases, and they usually revolve around medical type facilities where individuals need a service animal, and the employer indicates that it's not a reasonable accommodation we can provide because it's unhealthy for others around them. So here we have a pharmacy. I've seen others in hospitals where hospital employees need service animals. So it's important to really, if you're going to use that as a reason to deny a service animal, you really need to have a valid reason where this service animal is going to cause not just an inconvenience, but can significantly hamper or cause some sort of safety problems for your clientele or for your other employees. Some more disability accommodation cases also out of the 8th Circuit. The 8th Circuit's been very busy this quarter. We have Goosen versus the Minnesota Department of Transportation, where here an employee who has worked with heavy machinery was injured, and after a number of surgeries, the doctor allowed this individual to come back to work, but with certain restrictions. The employer determined that the employee was not qualified under the ADA because they couldn't perform the essential functions of the job. And really the linchpin of the case was, what were the essential functions of the job? The employer gave certain indications of what were essential functions. The employee said, no, I don't really do those things, or I don't do them for as long as you say I need to do them for. And the court really took to heart and held weight what the employer said, because they went through a thorough and individual assessment of what this person had to do as an essential function of their job. So again, it's important to have those really well-defined job descriptions to really go through an individual analysis of what someone's essential job functions are. And the court will take that to weight from an employer perspective much more than an employee if you have significant evidence as to what that is. On a pregnancy accommodation case, here we have Pfeiffer versus the Board of Probation and Parole at the Third Circuit. Two important things here. The employer, while they granted the accommodation, they waited for 2 months before granting the accommodation for someone who had a high-risk pregnancy and provided sufficient support. And the court ruled under the Pregnancy Discrimination Act. So while that act doesn't require that accommodations be provided, what the claim was from the plaintiff was that you treated me differently because I was pregnant. If I had asked for the same accommodation because of an injury or something not related to pregnancy, you would have granted the accommodation. But because I was pregnant, you didn't. So there was that form of discrimination that she was claiming she was treated differently because of her pregnancy. And secondly, even though an accommodation was granted, the court ruled that the 2-month time period was just too long and essentially acted as a denial of the accommodation. So it's important that you make decisions as quickly as you possibly can, that you don't dither and wait, because a court might deem that as a denial, even though you finally get around to it and actually grant the accommodation. Here we have a Title VII case under gender affirming care, which I think is extremely interesting. It's Lang versus Houston County. This was in Georgia at the 11th Circuit. And here the employer-sponsored health plan had an exclusion for gender affirming type care. The court ruled that that was discriminatory, essentially ruling that it treated transgender individuals differently than non-transgender individuals. And Supreme Court case law has indicated that whether or not one's gender identity falls under sex discrimination under Title VII, and therefore excluding that care for just this single group of people would count as discrimination under Title VII. Now, moving on to, which is, at least for us legal nerds, one of the most important, if not the most important case of the last 40 years, the overruling of Chevron deference. So prior to this case of Loper versus Bright Enterprises, what interpretations that agencies that were charged with administering certain statutes, such as the DOL, the EEOC, OSHA for our purposes, but really any of the federal agencies in the alphabet soup, that their interpretations, that their enforcement guidance, that those would hold, that courts were required to apply their guidance because these administrative agencies were the experts in administering these laws. Here in Loper Bright, they sort of turned that on its head and said, no, that these agencies have no special deference that they need to be given. Courts are going to make determinations as to whether or not the interpretive guidance or the enforcement are really in keeping with what Congress intended in enacting whatever the particular law is. So we anticipate significant litigation in the future, challenging interpretations by the DOL, EEOC, and OSHA, in particular with the new passage of the Pregnant Workers Fairness Act and the regulations that were just initiated under the PWFA, that employers will likely challenge those regulations, indicating that it's outside the scope of what Congress intended. And now it's for courts to make those determinations, and they might reasonably disagree. And so any changes or updates to regulations that are necessary due to ongoing litigation, we will certainly be on top of that and let you know. And with that, thank you. And I'm going to turn it over to Lana for her quarterly compliance lesson.
Thank you, Eric. That was really helpful. Really interesting cases this quarter. The quarterly compliance lesson, as Nell mentioned, is choosing FMLA. This is a question we get very often in various different iterations of the question, but specifically, we get asked whether an employer may permit its employees to save FMLA hours or decline to take FMLA, even if they need to take leave for an FMLA qualifying reason, or requested, maybe sometimes they ask for sick time or a different type of time off, but it's an FMLA qualifying reason. This often comes up with a well-intentioned employer who wants to make sure its employee has enough FMLA to use later. The employee may think that they're going to need it for pregnancy or another reason down the road. And sometimes employers say, well, let's let them save that so they don't use it up. But regardless of the intentions, the answer is no, you cannot save FMLA. The employee can't elect to save it and the employer can't let them. The regulations themselves specifically state that employer may not delay designating leave as FMLA qualifying. And doing so, not only may they not do so, but doing so is considered interference under the FMLA. Now, what if an employee says, I don't want to take FMLA, even if they are eligible and it's a qualifying reason? Can an employee delay this and choose to save or not take FMLA? Again, the answer to this is no. Employers are often surprised by this. Back in March of 2019, the Department of Labor issued an opinion letter that addressed this issue, specifically stated no. Once the employer, again, has acquired knowledge that the leave is for an FMLA qualifying reason, the employer must designate that leave as such. That's what the opinion says. And the employee cannot influence this process. Now, many employers ask, well, wait a minute. The regulations have a section that says an employer needs to observe an employment benefit or program that provides greater rights to an employee. In other words, we can make policies that are more generous to employees under the FMLA. So can we use that rule to allow an employee to save FMLA? So that's a good argument, but the answer is still no. In fact, in the March 2019 opinion letter, this was specifically addressed by the Department of Labor and rejected. So now we have, what if we have an employee that's out on workers' compensation that is on leave due to workers' compensation injury and receiving workers' compensation benefits. And it also happens to be, which it often is with workers' comp, a serious health condition under the FMLA. We have had employers ask if they can just let the employee use the workers' compensation time and again, save the FMLA time for later for another reason. And employees often want to do that and ask the employers if they can do that. Again, the answer is no. If the leave, again, is for a FMLA qualifying reason, the employer must designate that leave as FMLA. So this is true regardless of it's a workers' comp injury or for whatever reason the employee is out due to a condition that would be covered by the FMLA. So that sounds clear, doesn't it? But of course, there is a wrinkle. There is a Ninth Circuit case out there that came out before the 2019 Department of Labor opinion, Escriba versus Foster Poultry Farms. This case held that employees may decline FMLA and use paid leave instead. This came out, like I said, before the 2019 Department of Labor opinion. The 2019 opinion actually mentions this case, specifically states that it disagrees with the idea that an employee can decline to use FMLA. This has not been resolved in the courts since then. But so if you're an employer and you have employees in the Ninth Circuit, or if you're an employer located in the Ninth Circuit, make sure you consult with an attorney when these issues come up. So the Ninth Circuit consists of the following states: Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, or Washington. So this topic seems interesting, right? I think that, we could cover this in about an hour at a time because there's a lot of different iterations. This is a high level discussion of choosing FMLA. So if you are interested on this topic, it's very exciting that Shelby and I are actually presenting a webinar with the DMEC next week on this very topic, on whether employees and employers can choose FMLA. So there's a link here if you would like to register. And then we will also post updates very soon on our blog as well. So look for that. And thank you. And with that, I'll turn this back over to Monty.
Yeah, so we're at the part of the presentation for Q&A. We do have a few questions that have come in. I'll take these in the order that they came in. So the first question we have, and I believe this one will be best addressed by Lana. It is, they're looking for a further explanation or an example or definition around a qualified employee under that the Pregnancy Workers Fairness Act. Going back to slide 8.
Yes, so there's two definitions under the PWFA. One is the standard definition that is similar to what is under the ADA. And then the second definition is a qualified employee. Someone can be an employee that's qualified to receive benefits or accommodations under the PWFA, even if their job functions can be temporarily suspended. So that can, I mean, there's a lot of different examples that could entail. So I'd have to think about that more, but it's a very different concept than the ADA, where the ADA says, you know, the ADA doesn't apply if you're temporarily suspending essential job functions. So, I mean, if you, for example, if you're a clerk, cashier in a store and you're saying, I can't stand all day, I need an accommodation, under the Pregnant Workers Fairness Act, that they would say, first of all, this is probably a predictable assessment in my example, but under the Pregnant Workers Fairness Act, they would say that's even though standing may be an essential function of your job, the employer needs to accommodate that because it's a temporary, it's likely a temporary suspension of the essential function. It's only because they're pregnant that they're unable to stand. So that might be one example. There's probably several other, but I'll think about that more. That might be a good blog post idea for the future.
And the next question we have, this will probably be best answered by Shelby. It's related to the New York paid prenatal leave. We covered that on slide 31. Will Reliance Matrix, do we have any intentions on providing this as a private plan?
We're going to offer this as a tracking, as a leave only option. So we're still working on that. Stay tuned and we will provide more information to our clients. But yes, we're going to track it as a leave only.
Would we ever consider going anything beyond tracking?
I've not heard that yet, but I promise that as soon as I do, I will update everybody, and hopefully by the next quarterly docket, we'll have that information.
And then I believe we have a couple of seconds for one last question. This is probably best suited for Lana. The question is from a client that has an outside vendor administering their FMLA for them. And they're asking if the employee does not provide supporting documentation to substantiate the FMLA claim, that vendor is denying the FMLA. In this particular situation, how should that be handled?
So we can't give legal advice on this, disclaimer. And I don't know all the facts. I will say that supporting documentation, employers, they can waive that requirement if they want. You don't have to ask an employee to submit supporting documentation under the FMLA. If this is being asked in the context of choosing FMLA and saying I want to deny it because the person didn't submit supporting documentation, that's a different section of the regulations than choosing to designate something as FMLA. And we actually have an example like this in our webinar that we're going to cover in more depth next week, because there's a lot of different moving pieces to this. But for a short answer, I would say, one, you have to, if you're following the regulations and you gave the employee the proper notices about what the requirements were for medical documentation, and they didn't follow that, and there isn't a good reason as to why, and you're denying FMLA on that basis under the regs, that may be appropriate depending on the situation. But second, if the employer wants to give the employee FMLA or designated as FMLA, and waive a requirement in a certain circumstance, again, they'd have to consult with their attorney and make sure they're treating people the same. that is also, that may be permitted in certain circumstances under the regulations.
Thank you, Lana. I believe that concludes all the questions that came in, and as such concludes our presentation for the day. Really appreciate the attendance and look forward to continuing any communications we might have. Thank you.